Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. I want to direct your attention to pages 7, 8, and 9 of Judge Hippler's order regarding multiple state expert witnesses that the defense was either trying to have stricken or their testimony limited. One relates to Detective Darren Gilbertson. In this opinion, the issue of, number one, multiple suspects theory, which the defense has suggested, and number two, whether the issue that the house is no longer standing, might that work in favor of the state, the defense, or neither party? Let's take a look at what this opinion says. Judge Hippler begins by saying defendant disclosed expert opinions from Brent Turvey that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, he asserts that 1, there is direct and indirect evidence that attempts were made by the suspect or suspects to clean up the crime scene after the crimes, which would have taken far longer than the time interval alleged by the state. Number 2, that according to the defense, there were multiple weapons used against Kaylee, Zana, and that Ethan appeared to have been attacked simultaneously. Through his other expert, Rachel Orr, the defendant has also submitted evidence that he suffers from developmental coordination disorder, which has resulted in deficits in his fine motor dexterity and visual motor skills. His attorneys have argued in other motion that these deficits render it, quote, not possible, end quote, for Mr. Koberger to have acted with the speed and the coordination required to commit the crimes in the time frame alleged by the state. However, this has not been disclosed in an opinion of any of defendant's experts. In rebuttal, the state disclosed Detective Gilbertson, a lead investigator for Idaho State Police in this case. In his disclosure, he indicates he will testify that he and other investigators conducted time runs at 1122 King Road to gain an understanding of the approximate time needed to have carried out the crimes. A report of the time runs is attached to his disclosure. It was performed to determine if one person could carry out the crimes, and his opinion will be, depending on the suspect's pace and route, he could have carried out the crimes in approximately 2 to 4 minutes. Now, the defense comes back and argues that Detective Gilbertson's testimony should be excluded because, 1, the state failed to disclose how Detective Gilbertson is an expert in timed runs. 2, the relevance is minimal. 3, important data, recordings, photographs, and notes of this experiment were not disclosed. And 4, his opinion carries a risk of juror confusion and prejudice. On the prejudice issue, defendant claims that Detective Gilbertson was already familiar with the house when he did the experiment, and additionally, the house had been vacated, ladies and gentlemen, as opposed to being filled with furniture and 5 people, I believe the defense is pointing out here. And then finally, defendant also notes that the house has been torn down so that he is not able to conduct his own tests in rebuttal to these tests. The court has ultimately determined that Detective Gilbertson's opinions are relevant, will determine also and depend on what the defense's experts testify to at trial. So I'll leave you to reading the rest of this opinion, which continues on to page 9, but it will be very, very interesting, in my opinion, when testimony of these 3 experts come into play and what, if any, weight the jury gives to, amongst other things, the house not standing for the jury to tour if the jury would want to see the house itself. This will now conclude this episode of the Indie Zone. Thanks for joining us today.